the coordinator for this session. Yes, we're having a very interesting webinar today. We are the Corporate and In-House Counsel of the Chartered Institute of Arbitrators Nigeria branch. The theme of today's webinar is From Counsel to Arbitrator, Understanding the Inner Workings of the Arbitral Tribunal. My chair will always tell me, Ireti, anybody can be an arbitrator, even if you're an in-house counsel. Nothing stops you from being an arbitrator. Same thing to every lawyer or any professional. Anybody can be an arbitrator. So we have brought very seasoned and distinguished arbitrators that will give us real life experiences you cannot get in any arbitration textbook, even Garibon. Any arbitration, very good arbitration textbook. We're going to look at how to appoint both the a sole arbitrator, co-arbitrator, presiding arbitrator, all the dynamics, all the behind the scenes of the arbitral tribunal. We have a distinguished panelist to take us through everything, including handling fees, drafting of award, and navigating conflicts. Before, let me know let everything out of the bag. But you're in for a very interesting webinar, and I'm looking forward to that. Before we go in, we just have a very few ground rules. Please, let's keep our microphones muted if you're not speaking. And I've seen that people have started posting personal details in the chat. You don't need to post your personal details. While you were registering, we requested for your Supreme Court number, and that's sufficient for CPD purposes. Then you can drop your questions at any time in the webinar, in the chat. We'll record them and we'll ask at the appropriate time. I would like to call on the chairman of the Corporate and In-House Counsel Committee, Dr. Nike Esson, our indefatigable chairperson, to welcome everyone. Dr. Esson, over to you.
Good afternoon, everybody, and thank you for joining us this afternoon. On behalf of the Corporate and In-House Counsel Committee of the Chartered Institute of Arbitrators, I warmly welcome you. It is my pleasure to welcome you to this webinar titled From Counsel to Arbitrator, Understanding the Inner Workings of the Arbitral Tribunal. We are delighted to have you. And to our esteemed speakers, we are grateful for your time. We are grateful that you have accepted our invitation to share your experience and your insights. Like we advertised, what we will learn today, what we will garner today from this webinar is not something you will find in any textbook or in any legal material. And it is part of the committee's ongoing commitment to creating practical and experience-driven conversations for in-house counsel, dispute resolution practitioners. While arbitration is often approached from the perspective of rules and procedure, what we typically do not see is, in any textbook, like we said, is what really happens behind the scene. Today's discussion is therefore very timely, and it's useful and valuable for both the in-house counsel, the corporate counsel, dispute resolution practitioners, even those that are still in the school, so that they can understand exactly what happens behind the scene, how tribunals make the decisions, how they even appoint the presiding arbitrators, and so many things that I am sure at the end of the webinar, the session today, you'll be glad that you attended. Again, thank you very much, everybody, for joining us. And our speakers, we are so sure we are going to have an exciting time, and it's going to be very insightful and engaging today. Please feel free to drop your questions in the chat box or in the question and answer section of this Zoom platform. And again, please have a good time listening to everybody. Please feel free to engage, reflect, and take advantage of the opportunity to learn from the wealth of experience we have gathered here today. Thank you very much. I look forward to a very insightful and engaging session. Bye-bye from me. Thank you.
Thank you. Thank you so much, my chair. So I have a very Herculean task to read out the profiles of our distinguished panelists in a minute or two. So I'll just give you a very brief summary. You can find their profiles online or at their LinkedIn handles. So I'll be introducing Mrs. Fumi Roberts. She's a distinguished arbitrator, adjudicator, and mediator with extensive experience in high stakes dispute resolution. She's a member of the ICC International Court of Arbitration and the Permanent Court of Arbitration at The Hague. She serves on multiple arbitration panels and corporate boards. Please do help me welcome Mrs. Fumi Roberts. I'll also
Pleasure
be
to
in.
be here, Ritzy. Thank you very much.
Thank you. She's my big mommy in the legal profession. Thank you, ma. So I'll also be introducing Mr. John M. Ohaga. He is a senior counsel of Kenya, chartered arbitrator, senior partner at Triple OK Law LLP with over 30 years experience in international arbitration. He has served as sole arbitrator, co-arbitrator, and presiding arbitrator in high-value disputes and is ranked band 1 by Chambers and Partners and amongst Africa's top 50 arbitrators by Legal 500. Please join me to welcome Mr. John Ohaga. We also have with us Sir Bola Akinola, SANCIAB. He is a highly regarded legal practitioner with decades of experience in corporate and commercial law, arbitration, and dispute resolution. A senior advocate of Nigeria and fellow of CIAB, he has acted as arbitrator and counsel in complex dispute and domestic and international disputes and remains a leading voice in arbitration practice in Nigeria. He is the immediate past chairman of the Chartered Institute of Arbitrators Nigeria branch and a partner in the Law Union. You're welcome, Sir Bola Akinola.
Thank you very much. Good day, everyone. Glad to be here.
Thank you, sir. And the fourth speaker is Mr. Paul Seals, fellow of Chartered Institute of Arbitrators. He is a leading international arbitrator and mediator with over 30 years experience in complex cross-border disputes. He's the founder of Dispute Resolution Partners. His legal career was complemented by senior executive roles as CEO and director of international businesses, and he brings very strong commercial insight. He's one of us in-house counsel. Corporate and in-house counsel, yes. Ranked a global leader in arbitration and mediation, he lectures globally and trains arbitrators. We welcome you, Mr. Paul Seals.
Thank you very much, and great to be here.
Then we have someone who will help us weave together all the conversations we're having today, Mrs. Abidemi Ademola. She's a seasoned corporate counsel and governance professional with over 30 years experience across Nigeria and West Africa. She's the former general counsel at She had worked as former general counsel at Unilever Nigeria and legal director at Guinness Nigeria. She advises boards on risk, on governance and risk. She's the founder of DFA Solicitors, a fellow of ICSAN, and a respected thought leader in corporate governance and compliance. You can see the lineup of speakers and moderators we have today. So let me hand over to Mrs. Abidemi Ademola to take us right into the panel session. Thank you very much.
Thank you very much, Mrs. Banjo. Good afternoon first of all, to our esteemed chair of the Corporate and In-House Counsel Committee, and to our distinguished faculty this afternoon. You've heard the profile, so you know that you're in for a fantastic time, learning time this afternoon. We have already over almost 250 people, on this call. So I'm really excited. People have been buzzing me and asking questions. And like you heard, our chair had mentioned that this is not something you find in the textbook. This is something that is practical and is down to earth. And the people that would be addressing us today, there are people that know their onions, people that have done it. They've been there. And so today, just sit back, relax, learn, enjoy the session, and please let your questions, when we get to the Q&A session, make sure that your questions are buzzing as well. All right, so today we'll be exploring the topic from counsel to arbitrator, really understanding the inner workings of the arbitral tribunal. And we have a couple of, we have a lineup of questions that will help us really deep dive into what really goes on, within the arbitral tribunal that you don't see, the parties don't see most times as well. And then, you get a fantastic award and you're just wondering, how did this happen? So today we're going to know the what is the inner workings, how does this really work? So welcome again to our distinguished panelists, and we'll get right into it. The first question I want to ask is around, when you get that communication, whether it's an email or it's a phone call or it's a WhatsApp message, whatever, communication that appoints you as the arbitrator, what do you do? What comes to your mind? What's the first thing you think about? And what are the next steps that you take to set up the tribunal? So you've been appointed as an arbitrator. Another party has also appointed another arbitrator, and you're supposed to have a 3-man panel of arbitrators, for instance. So what happens? What do you do? My question will go first to Mrs. Roberts. Ladies first. So let me do ladies first today. So over to you, ma'am.
Thank you very much, Mabidemi. And it's a pleasure to be here, because in recent times, what I tell people is that I want to die empty. Everything in me, I just want to pour out and share with as many people as possible. I wasn't surprised that you called me first. So I'm the only woman on the panel, and I look forward to sharing things also from the female perspective. When I received that call, you see, it depends on how it comes. Because nowadays, what you see is communication from counsel, asking whether you are conflicted, asking about your availability. So that prepares you for, okay, is the appointment coming or not? So when it comes, it is no longer a surprise. But the one that will surprise you if you just get a letter out of the blues appointing you, but that rarely happens. And if it does happen, perhaps what you do is just calm down, because it can be very exciting. And the reason why I say this is because unlike a decade or two back, when there are very few arbitrators in the space, then you get more appointments. But in recent times, there's so many arbitrators, well credentialed to sit on arbitration panels. And like Reti said at the beginning of the conversation, anybody can be appointed as an arbitrator. You can even appoint your driver if that's what you feel like doing. You don't have to be certified to be an arbitrator before you can act as one. So I'll say calm down and think, do I have the time to do this? Because sometimes I would say it also depends on whether it's your first arbitration or your second or your third. If I share my own experience about my very first arbitration, I was just lucky. I'd been arbitral secretary to one of the leading arbitrators in Nigeria, retired Justice Kayode Esho. And he was the one supposed to be appointed. And he looked at me and said, Ms. Roberts, I can't deal with this. I have so much on my plate. Can you do it? I was initially hesitant because it came as a surprise. And I was like, I'm not sure. So I said, yes, you can do it. And then I sat down, thought about it, and I realized that, yes, I could do it. So he made that recommendation to the parties. And that was how I got my first appointment. And because, thankfully, I did creditably well, he then recommended me for my second arbitration. And then it went on from there. So I won't say that, like everything we're going to be discussing today, There's no right or wrong answer to anything. If it is a three-man panel, to go back to what you had asked, and you had been appointed as party appointed arbitrator, and the other party had appointed, you need to appoint a presiding. It means the tribunal has not been established yet until the presiding is appointed. But then you have to make sure that you're eligible to take up that appointment as a party appointed arbitrator. So what do you do in terms of getting the presiding? You have to reach out to the other party, to your co-arbitrator, because it's not something you can do alone. And that may take me into another length of explanation of how you appoint the presiding. So I'll just keep this short and simple, since this is my first introduction into the topic. Thank you.
Thank you very, very much. Very insightful already, what you've said about, you calm down and think first and make sure that, you have the time and you have what it takes. It was also interesting that you talked about the fact that you were recommended by someone that you had been the arbitral secretary for. You took that on. So we'll talk about that later, but I think that was also something I picked up to say. Sometimes people want to start from just being an arbitrator now, but you had your first experience, as the secretary to an arbitral panel, and it was based on even what you did at that time, I'm sure, was why, Justice Kayode Esho could recommend you. So just some very good learnings there already. Thank you very much. So I will go straight on to Mr. Sales and just ask, Mrs. Roberts was beginning to go into how you appoint the presiding arbitrator. And I would just like you to take it on from there and explain to us, in cases where you've been a joint arbitrator and you and the other parties arbitrator, you needed to appoint a presiding arbitrator. How did you go about it? And how did that, pan out at the end of the day? Over to you, Mr. Sales.
Thank you very much. Yes, it's a very interesting question, because a lot of it is done informally. So again, the whole theme of today is what happens behind the textbook, and a lot of it is who you know between the two party appointees, and who do you think would be a good fit for the case, and also for me a good fit for myself and the other party appointed arbitrators. So the first thing I will try and work out, if I don't know the other party appointee, is a bit about their background, their strengths, their weaknesses, how I think that person and I will work together, and then what sort of person might best complement both us as a working tribunal and the subject matter of the dispute by way of chair. And that might be somebody I've worked with before. It might be somebody, I'm very fortunate, I have a management team with lots of years of experience in the market. So I will often lean heavily on them to say, who do you think might be a good fit? One of the nice things about sort of arbitration practice is it often can be somebody that I know professionally in the marketplace. I think that's a distinguishing feature of international arbitration, is we do get the opportunity to appoint each other, and we do get the opportunity to, build good relationships with people all over the globe. And so I think that side of practicing as an arbitrator is really important, getting yourself well known in the international community, so that community is hopefully thinking about you when it comes time for these sorts of appointments. So for me, it's typically an informal process. I'll try to put together a short list, working with my management team, working with the other party appointed member, and then really sort of work through that list, check who's available, check that they have the time and the commitment to give to this, because I think that's becoming increasingly important. I think the market has sort of moved past being willing to wait for us arbitrators anymore. We like it when they do because it allows us to squeeze in more work. But I think, being available, being able to render an award in the time frame that the case either warrants or the time frame that is set if it's an institutional appointment is really important. As I say, the days of taking years and years to do the awards because the tribunal are simply too busy has kind of insensibly, and I think is a good thing, has passed by. So I think whether it's your own appointment or the appointment of a chair, availability and ability to commit to the process is really important. And from there, for me, as I said, a typically semi-formal, mostly informal process of finding the right person that I think will fit the profile of the case and fit the profile of myself and the other party appointed arbitrator.
Thank you very much. Quite insightful. I will just take one point, which is about looking for someone with a good fit, somebody that, you can work together with in the team. Thank you. I'll go on straight to
I'm
Sir.
sorry, Abidemi, before you go on, I'll just like to add something to what Paul said.
Please.
I agree with everything Paul has said, absolutely. But in the last couple of years, something has crept into the arbitration space, particularly in international arbitration, which is parties wanting to know and have a say about who the presiding arbitrator is. So some of them would insist that you run the names you are considering by them and tell you that this is their preference and so on. They don't have the right to make the final determination. It is still the right of the co-arbitrators. But sometimes in recent times, that has happened quite frequently when parties want to know who you are considering and of course the two party appointed arbitrators have to determine how to handle that. If one of the parties insists on knowing the people you are considering appointing as presiding, I just said to chip that in.
Thank you. Thank you very much, Ma. That's well noted. Mr. Ohaga, I can see you already. So do you have anything to say about that? When the parties insist, how do you approach that? And then I would like for you to also answer a follow-on question about the arbitral secretary. How do you go about appointing him or her as well? Because what you are trying to get is a tribunal that works well, that there's a lot of that is efficient, that is quick and sharp and all of that. So how do you also go about appointing the arbitral secretary? What do you look out for, and whatever else you want to talk about around that? Sorry, I think you're speaking on mute. Wow, what's going on? Sorry.
You are muted. You have to look for the button at the bottom of the Zoom link, left-hand side, typically.
Okay, maybe we should take Chief Akinola for now, and then we'll come back. Well, can you speak now? I think you're on now.
Yes, sorry. The host needed to unmute me. I couldn't unmute myself. That's what I was trying to say. I'm not very well versed in sign language. But yeah, thank you very much. Very nice to be able to join this panel. It's a really exciting panel. And I'm very happy to share my experience. So, yeah, I fully associate myself with what Fumi has said. And as well as what Paul has said about choice of presiding arbitrator and choice of or giving the parties an opportunity. There is certainly a growing trend where parties want to have a say. The difficulty, of course, is that when the parties sort of cannot agree because the parties can only speak to their party-appointed arbitrator. They cannot speak to the other arbitrator. And then the two arbitrators have to get together, and then they have to make a decision. And eventually, notwithstanding what the parties have to say, I think the two arbitrators have to make that decision. And I'm always conscious that once you're appointed, you don't belong to the party that appointed you. You can take their views into consideration, but you must begin to make some distance between you and that party. And some parties misunderstand that. They think that because they've appointed you, therefore, they have an open line to you. And I think that we have to be very careful about drawing that line between party appointee and neutral. Now, with respect to the question of tribunal secretary, in my experience, when it's an institutional arbitration, for instance, I find the PCA has a very, very efficient tribunal secretary service. I really, really appreciate it. But when the institution does not offer that service, then it falls on the tribunal to decide. In my experience, more often than not, in the tribunals I've served in, we have eventually left it to the chair to designate the tribunal secretary. The reason being that the chair must work very closely with the tribunal secretary in the sense of the issuance of procedural orders, directions, and so on and so forth. The general conduct of the tribunal falls on the chair more than it does on the wing arbitrators. And so that's been the default that I found. In one situation, we went to a service that offers tribunal secretarial service now. There are more and more professional tribunal secretaries who are setting up and offering themselves. And in one situation, we've gone to that and simply incorporated the tribunal service fee onto the tribunal's fees and advised the parties that this is what has happened, this is what we've decided to do, and this is how it will be met. So that's how we've gone about it.
Thank you very much. Well noted. I go to Sir Akinola, and I would just like us to move quickly and talk about money. All right. And I think that you're the best person to kick off this part of the conversation.
You can bet on that. I love money. Some people will tell you
you
it's
made
not
the
about
right
money.
choice in that.
Anyways, so the question is, how does the tribunal decide on the fees in hard hoc cases? I know that the institutions would usually have, fee schedules and all of that, but please tell us a bit about, about that, the money talk, within the arbitral tribunal.
Okay, before the money talk, let me just do a minute on the past subjects that you've made my other panelists talk about, and principally just to reiterate the fact that parties play a major role. Don't forget that arbitration itself is a party-driven process. So when you are appointed, it's not yet who, it's not just because you get that email or that phone call, it doesn't make it hunky-dory that it's all settled until you have your preliminary meeting. Because even at that stage, even though it's becoming late, but in the life of the proceedings, of the arbitral process, it's still early days. They can still blackball you and anything can happen. Essentially, the parties must run a due diligence on all the nominated arbitrators. And it's important. I always tell people, the only first appointment or the only appointment you can get through a lobby or man, no man is the first one. After that first one, It's your reputation that will determine whether you will ever be reckoned with or whether you'll be dispensed with. And the arbitration community, as large as it appears, is a very small community. We talk, everybody knows who does what. And the moment parties know that if you appoint this particular person, it probably will amount to a waste of time because at the end of the day, that award may be suspect or susceptible to being set aside. People will avoid you like plague. So your integrity comes in, your being able to deliver on the process comes in, and in all these, the parties are observing your arbitrators in the event of it being a three-man panel observing. And nobody wants a lemon as a co-arbitrator. Now to the money talk. You see, it's a very interesting area because a lot of times you get embarrassed by the way parties will react. How do you determine your fees? Usually, personally, what I use is the institutional schedule of fees as a guideline, but then it remains just that, a guideline. It's up to the parties to now decide and agree that that position that you've taken, the quantum that you've decided, maybe it's 5% of the quantum of claim or whatever percentage it is, they are in agreement with it. I will tell you that in practice, the parties will always go against each other. But when it comes to issue of money, that is one time they will align in thought because the moment party A says, hey, that volume you're asking for is so high, party B would align and agree that, hey, it's too much and everything. And it becomes awkward. You know your worth. But at the same time, you don't want to be a sellout. Um, I've walked away from a couple of appointments simply because it appeared that parties believe they have the power. Yes, they do have the power to appoint, but they cannot force the fee that I'm entitled to on me. I have a right to evaluate the time I'm, making available to get the process, the job done, and to see whether it's worth my while to take on that appointment or not. So nothing is cast in stone. Miss Adibola, Mrs. Adibola, nothing is cast in stone. It takes a lot of skill. You don't want to appear cheap. At the same time, you don't want to be too steep. Otherwise, again, your reputation goes, hey, that man, he's just going to clean out the stable and collect all your money and whatever. But the truth is, for as long as you're delivering on the quality, I think parties must be mindful that they are spending quality time to have that award done. And it's probably worth the while to pay a good arbitrator that will not be compromised and that will be able to deliver on what is expected. And what is expected? A good, valid, recognizable, and enforceable award. Thank you.
Thank you. Thank you very much, sir. Very well said. I'm still talking about money. I'll just move to Mr. Sales to ask about whether you've had situations where there have been tension around, money matters within the tribunal. I don't know. We're all trying to learn today. We want to know whether when the fees are agreed, is it shared amongst tribunal members? Does a particular arbitrator take more, maybe the presiding arbitrator? Or how does it happen? What happens with, the allocation of the fees? And then have there been situations where there've been tension that you want to share with us, and how was that managed?
Yes, look, definitely there are tensions, and definitely some arbitrators come in with some quite different expectations around, dare I say it for this audience, what they think they are worth versus the reality of the situation. So I've seen a few where actually those tensions have caused quite a disruption.
Sorry.
I came in 2 or 3 years ago on an arbitration which had basically stalled for 6 months, and I didn't know why, of course, because I didn't know anything about it. And speaking to one of the tribunal members who had remained in place, and I was coming in to replace somebody else, to find out that the reason that the arbitration had stalled is there was a 6-month dispute between the tribunal members on the allocation of fees. And the incoming tribunal member had insisted on a very high proportion, even though he wasn't the chair, and even though the arbitration had been running for quite some time, and so the fee fixed by the institution was being used up, and so the pot of money available for the arbitrators was shrinking, and that caused a huge disruption to the flow of the arbitration. And of course, why there is a disruption at the tribunal level is never fed back in a concise or transparent way to the parties. So the parties are left sitting in that instance for 6 months, waiting for an interim award on jurisdiction to come out, not knowing what's going on, and of course becoming incredibly frustrated. And so unfortunately, I have seen situations where the fee dispute, the fee negotiation between the tribunal becomes a very direct factor in the conduct of the arbitration. And that, of course, is something that does the arbitral community no good whatsoever, because that plays into the hands of anybody who wants to sort of criticize the process as being too slow, too expensive, etc., too greedy. So unfortunately, those situations exist. Back to the point about the sharing, typically, it's not a rule of thumb, but typically on a 3-person tribunal, the chair will often take a greater share, 40%, and then 30-30 for the 2 co-chairs. And sometimes that's reasonable because the chair is carrying a greater burden. Often the chair can carry a lot of the procedural burden because the chair can make procedural orders by him or herself. And other times that simply doesn't work. And another example on a different matter, again, I was party appointed, so my allocated share was negotiated at 30%, but I sat with 2 civil engineers. And it was a highly contested legal civil law matter. And so about every 3 months, I was writing an interim award or dealing with an application for interim measures. So there, an overwhelming portion of the actual work fell on my shoulders because I was the only legal person. I was doing all the drafting of the awards, etc. So what do you do? Well, sometimes you just say, "Oh, well, I'll live with that because it's great exposure. I'm working with great people. I was party appointed or whatever." So you make your own determinations as you go about how practically you want to deal with it. But yes, to answer the question in the round, unfortunately, inter-tribunal conflict around fees is a reality, and as I said, I have a very distinct example of it really impacting upon the quality of what is being delivered to the parties, which is the great shame.
Yeah. Thank you. Thank you very much, Mr. Sales. That was insightful. I see
Can I just
Mrs. Roberts.
Can I just add that actually we have lost an appointment because we were not sufficiently wise about our choice of presiding arbitrator. We had my co-arbitrator and I decided that we would exchange names, and we eventually settled on a name who happened to be a barrister out of London in view of the subject matter. However, his rates were inflexible, and the parties eventually decided that given that inflexibility, which went way beyond their budget, because the parties themselves have no choice, no say in the choice of the chair, it had been concluded, the tribunal had been formed. And so we could now withdraw the appointment and look for another chair. And so the parties must have, we don't know what happened behind the scenes. They must have got together, but eventually they came back and they said, well, we've decided that we're not proceeding with this dispute. But it was clear to us that the reason they were not proceeding was because the costs were going to be too high. I think the barrister that we selected said he couldn't go below £800. I think that was the rate then. He'd come down from £1,000, and the parties had a budget, and they just couldn't fit it in that budget. So sometimes it can actually disrupt the entire tribunal.
Thank you for that. I think it just goes to Mr. Sill's earlier point that the parties would disagree about everything. But when it comes to the fees, they tend to agree, especially when they're trying to beat it down, right? Thank you.
Can I just chip in something on this issue again? You see, sometimes this awkward moment is usually created by the parties. Oftentimes, counsel, in preparing the claim, they come with a mindset of that they take into the courtroom. It's like you're making a claim for maybe you are justified to make a claim for $500,000. You now put up a claim for $2.5 million, hoping that along the line you may get a judgment for 1.5 or 2 million. But the truth is, in arbitration, the claim cannot be speculative. You must ensure that what you're putting forward as a claim is something that you can realize. It's a realizable claim. Why do I say this? The fees payable to the arbitrator is derivable from the quantum of what you're claiming. So when you have overinflated your claim, you're actually doing a damage to the parties, because at the end of the day, you probably may end up paying the arbitrators more than even what the value of the claim that you can prove becomes. So I always tell people, take away all these speculations. In arbitration, your claim must be real. It must be something you can prove. Take out the realm of general damages. He did this, okay, now you're asking for 2 million. For every cent that you are making a claim upon, you are just widening the gates for what the arbitrators may decide to take as their fees. So I come back to what, again, I always tell people. I disagree that anybody can be an arbitrator. Or rather, well, anybody can be an arbitrator, but you will live, swim, or sink with your choice of arbitrator. Because if you choose anybody that doesn't have, sufficient skill, that is not matured on the process, that is not matured or informed on the subject matter of the claim, and you just say, well, anybody can, you will suffer greatly. Brings us back to what the Institute is about, with the corporate and in-house counsel trying to ambulate. The bottom line is training, training, training. You must ensure whoever you appoint, either as counsel or as an arbitrator, is well trained in the arts and skill and science of arbitration.
Thank you so much, sir. That was a fantastic counsel. Thank you. Mrs. Roberts has had her hand up, so I must allow her to speak.
Yes, Chief, I'm sorry, Sir Kiola took the words out of my mouth. And I would also just like to point out that in recent times, what John experienced in Kenya is also being experienced here in Nigeria. When your fees are too high, the parties would rather go to court, and they'll agree. So they'll compromise the arbitration agreement and rather take the case to litigation. And it is happening more and more frequently. Another recent trend is to avoid a three-man panel because of the cost and the fees. So you find more sole arbitration than a three-man panel. Sometimes for high-stake disputes, I'll say that in the last 2 years, practically all my appointments have been as sole arbitrator. And in at least 2 of them, the parties compromised and amended the arbitration agreement from a three-man panel to a sole arbitrator, all because of fees. And because fees in arbitration is real fees, the cost. The cost is not like you go to court and you spend 10 billion in court and the court awards you cost of 100,000 naira. No. It's indemnity costs in arbitration. You pay exactly what the parties have expended. So it is not cheap. And that is why what Chief said is also important, that as arbitrators, we need to be mindful of taking all these circumstances into consideration, looking at the profile of the parties and determining whether the parties can actually pay what is being requested. If it is an institutional arbitration, the parties don't have a choice. They have to pay the fees set by the institutions. And for example, ICC, they won't even take the case forward if those fees are not paid. Thank you.
Thank you very much. It's been so interesting.
We've lost you there, Bidini. We've lost you.
No, it's the internet because she's frozen.
We might have to ask ourselves some questions.
Yeah.
I'm going to fill in a bit of the space, Mr. Roberts. What you said is so true and so interesting, and I think part of what the arbitral community needs to be very conscious of. I'm seeing what you said happening all over the world, which is parties opting out of arbitration agreements and taking matters to the local courts in preference because of costs, because of time delays. And so I think we sit at quite an interesting crossroads, I think, for the international arbitration community of how we respond to some of these realities. And unfortunately, again, talking behind the textbook, too many of us are comfortable with the status quo, whether that's big charge out rates as arbitral tribunals, etc., and not really willing to work hard enough with the parties to do things in the manner and in the established theory of why we got into this wonderful thing called arbitration in the first place.
Well, Paul, what I would say is that the truth is, I agree. Arbitrators have to take a reality check. Sometimes our expectations are too high, and most often than not, it's premised on what you see. The usual thing is you see the claim that gets you excited. Oh, this is a large, claim, and of course your mind goes to the bottom line. But if in the reality of things, you find that it's quite empiric, it's skewed up, is a bloated claim. I bet the best thing to do is to advise the parties. Advise because a lot of them approach arbitration from a non-informed view. And that is why at the end of the day, they will come up with a conclusion. Arbitration is so expensive, too expensive. It will be so expensive, it will be too expensive if you do not go there with the proper mindset and you are not there properly guided. Because you can waste a lot of time and a lot of money doing nothing. And at the end of the day, the process is what will be attacked. Not forgetting that really the problem lies with whether it's that in-house counsel that has not advised properly, or whether it's the party that is over excited and thinks, hey, I can make a deal from this claim, and it's my time to make a lot of money. So really, it's not our job as arbitrators to start doing training under appointment. You've been appointed. What have you been appointed to do? To sit in as an arbitrator and evaluate the evidence that has been put, just opposed with the facts presented, and do a proper job and prepare an award. Sometimes even if you over advise, again, it can be taken as a misconduct, because they will tell you you've devolved into the arena. So it's a situation where you cannot really win all the time. But sometimes when you counsel, the parties, some of them are smart enough. Like Fumi said, in a situation where a three-man panel, you've been able to convince parties to quickly review the arbitration clause and whatever, and agree to a woman. It's good advice, but sometimes, the recalcitrant party, the party that is really in default, that doesn't want to pay, will not agree to any good counsel.
And
but I take the view that, sorry,
yes.
for me, go ahead.
Please go. No, John, please go on.
Well, I was going to say that I take the view that, when I start off, I always, especially where it is clear that costs are a concern, I always try and explain to the parties that actually the question of costs is in their control, because it really is a question of how long they spend before the tribunal. It really is a question of what strategies they deploy. And I try and deploy the most efficient case management structure. The difficulty that I find sometimes, and it's very interesting, is sometimes the party that was most cost averse wants to spend the longest time with their opening statement, with their written submissions. They want more and more time with cross-examination. You want to focus them on their cross-examination, and they think that that's interference. And so it's counterintuitive, but I always start off by saying, listen, this is my rate, but it is within your control. Whether you spend 5 hours or 50, that's really up to you.
Can I just say that, John, I quite agree with you. And that works when you're talking about how payment is made. If you bill on an hourly basis, or do your billing per minute, yes. But when you're talking of a lump sum payment, those would probably be different. But I always say something that a lot also depends on the counsel to the parties, the people who drafted the agreement in the first instance, the contract. You need to look at the profile of the parties to that arbitration agreement. At the very beginning, when you're putting the contract together, you look at the stake of the contract. And then you look at, is it a multinational contracting with a medium-scale entrepreneur? You would like to take all those into consideration before inserting a three-man panel. I've seen three-man panel in lease agreements, 3-year lease with, if you look at the quantum of the rent involved, it is less than 5 million naira. And they're putting a three-man panel in the arbitration agreement. It just doesn't make sense.
Yeah, you're right. I think people just copy and paste. People who just copy and paste the arbitration agreement. And I know that we've discussed costs and fees exhaustively. I just want us to move on a bit, if you don't mind.
Welcome back, our moderator.
Yes, thank you. So I just want us to talk about the tribunal dynamics a bit, because that's really also very, very important. Obviously, costs would affect or impact the dynamics as well, the fees and all of that. So you've touched on it a bit. However, when the tribunal is set up, in your experience, do you see that, the arbitrators participate equally? Are they equally engaged? Or do you see that sometimes you have some, or one or two that would be a bit, maybe not be at the same level as the other ones as well? And how do you sort of manage that sort of situation when, you see that an arbitrator maybe is busy with something else and we need to quickly, Mr. Ohaga was talking about efficient case management strategy. You want to quickly get through this, to try and manage the cost and all of that, and even your own time. But you're not getting that same feeler from maybe one or two of the other arbitrators. How do you sort of manage that? Is where since Mr. Oga talked about efficient case management, let's start from you. How has your experience been? How have you handled that?
Well, I think it's when you're presiding, you're more in control. And when I'm presiding, especially with your terms of reference and your first procedural meeting, I try and move it as quickly as possible, as efficiently as possible, in order to get through, because more often than not, you have circulated your draft procedural order number one. The parties have been able to look at it. Their comments are very focused on, there's just a few things that you're going to discuss there, timelines for the exchange of their respective pleadings and submissions. There's a lot of generic standard things there that you can get through very quickly. I find it more frustrating when I'm not presiding, because you then have to sort of defer to a presiding arbitrator. On one occasion, I think we had a preliminary meeting that took two and a half hours, and I could not understand why we needed 2.5 hours. But the presiding arbitrator wanted everybody to comment on each item, counsel as well as his co-arbitrators. And I just could not understand why, and I knew we were going to be in for a rough ride once we started off on that footing. So in that case, you have to show deference, because also the authority and dignity of the tribunal is something that you have to sort of demonstrate to the parties. You cannot appear to be undermining your presiding arbitrator, however much you think that he's not going about it the right way. So it is finding that balance. And the reality is, a lot of times when you're in these tribunals, that might be the first time you're working together. So you don't really know too much about your colleague's style and so on and so forth. I tend to be very vocal. I try and cut through. If cross-examination is wandering around, I try and bring people back on track, and so on. It's easier when you're presiding, but when you're co, then you're trying to take your cue from the presiding arbitrator. Once you've got a bit more comfortable with each other, and especially pre-COVID, because then, you were not just meeting across a screen, you were actually meeting physically at breakfast or at coffee break or just before you commence. You could have a chat about how you expect things to proceed, and you get more familiar with each other, begin to, share jokes. You've had a meal together, you're easier with each other. So it gets much easier as you go along. I think by the time you get to the end of the hearing, you should be very you should be very comfortable with each other. That's my expectation and my experience.
Thank you very much. Thank you for sharing that, Mrs. Roberts. I just want to ask about, the sort of informal communication that go on between, arbitrators within the panel. What do you typically see? Emails, WhatsApp calls? Do people call? Do you call up, like Mr. Alga was referring to, if the presiding arbitrator, for instance, was taking things a bit slower than it should be, can he give him a call? What can he do? How do you manage that sort of, informal communication amongst the arbitrators? What has your experience been, and what is best practice?
As I said at the beginning of our conversation, there's no right or wrong way of doing it. Some presiding would insist that all communication be by email. And you tend to get that from older arbitrators who are not used to more modern platforms of communication. Nowadays, you have arbitral tribunals set up WhatsApp platform for communication, call up one another. But all this needs to be agreed as soon as the tribunal is established. Because if you don't, you may run into a problem that I ran into. This was several years ago. I was party appointed, and my co-party appointed was a retired Supreme Court of this, a retired Justice of the Supreme Court. He then appealed to me and said, way older than practically older than my dad. And he was like, please, I want us to consider appointing another retired Supreme Court justice, which goes to show what Paula said, that some of these things are done informally. And said, both of us are retired. We're hoping that this will be our meal ticket until we pass on and we become arthritic and are unable to do anything. And I agreed. From the very first meeting, it just showed me that they don't have a clue about arbitration. And I knew I was in serious trouble. And at the preliminary meeting, because the presiding is in the middle, I was on one end and the other co-arbitrator, the retired justice, was on the other end. The two of them would whisper to one another. And then the presiding arbitrator would make an announcement. So I had to tell him that, please, can we have a brief chat? And I explained that, no, whatever you discuss with the other arbitrator, you need to run it by me and we'll reach a common ground before you make the announcement. I'm sorry. You mentioned that as our very first meeting, but I forgot. And he did that about 3 or 4 times. And for me, it was very frustrating. So at the meeting we held at the end of that first meeting, I had to let him know that he should not do that. So anytime he wanted to do it, I just poke him, sir, can I know what you're talking about? So, like I said, the circumstances, the dynamics may be different. It depends on your co-arbitrators. You will have co-arbitrators who act as if they are counsel to the parties, to the party that appointed them. That can also be frustrating. So you need to discuss all this at your very first meeting. It will not be great if you have not worked together and the first time you're working together is your first meeting with the parties. You need to agree and set some ground rules amongst yourselves before you meet with the parties so that you have cohesion on the tribunal even before you talk to the parties.
Fantastic advice. Thank you, Ma. I want us to go to, I have a question still on this tribunal dynamics around we talked about presiding judge maybe earning 40% while the other, might earn 30% each. Is that the same with voting? So when you need to have a decision, when you need to arrive at a decision, is there a weighted does one arbitrator has a higher weight than the other? How does it work in terms of, coming to a decision or voting on a decision?
Who do you want to answer this?
I was going to go to Mr. Sills, but you
Okay,
can
go ahead. No, let Paul have it.
because I know you.
Yeah.
Yeah.
I'll focus on a part of that question because it's a really interesting question, and the short answer is it should be equal vote and equal influence on the outcome. I think and I open this up to my other panel members to comment on, because I think where it gets really interesting these days is we are seeing a broader range with focus on diversity and inclusion, and people coming into arbitration appointments at a younger age. I think we're seeing some quite interesting influences on that. And I use the example of where you have a very senior arbitrator, and I've seen this in investor state cases, and very inexperienced, very technically competent, wonderful people, but very inexperienced party appointed arbitrators, because the parties have very, correctly at times and very consciously selected arbitrators to introduce new people into the market, et cetera, et cetera. And I think when you have that sort of dynamic, we get some very unintended consequences from that. And one of the unintended consequences is the opportunity for presiding arbitrators to really influence outcomes, because the party appointed arbitrators don't have the experience, perhaps are sort of still finding their feet, don't have the confidence to stand up for where they think matters should be going. And so I think that sort of parity or equality of vote issue is actually quite complicated, and at times probably very far removed from what the ideal ought to be, which is an equal say in the outcome. So that's my comment on it. I think the intention is very clear. I do worry at times how much people are swayed in their deliberations by seniority, by Mrs. Roberts' point, an ex-Supreme Court justice on the panel who has a very black and white view on something. Those are the tricky circumstances where people really need the confidence, which is very difficult when you are still learning and still becoming experienced as an arbitrator, to stand their ground on what they think the outcome on particular matters should be. So it's a difficult situation, I think.
So what if the arbitrators don't agree? What happens? Has there been a situation like that, Sir Akinola, that you've witnessed? How was it resolved?
There's no way the
Majority.
arbitrators won't agree. There's no way they would agree, which is
So they will.
why it's either you have a sole arbitrator panel, or a 3-man panel, or a 5-man panel. You need to have an odd man panel so that you can have a decision. Sometimes, if the thoughts are so clear and the evidence that are weighed are so obvious, you may have a consensus, award given by the 3 arbitrators. But under those circumstances, are you going to have a hung panel? Because it's a 3-man panel. So it is either all the 3 are for, or all the 3 are against, or 2 are for, or 2 are against. In any event, you will have a decision. And that is what, again, informs the constitution of the panel. Now, in situations where you say, well, maybe one of the panelists is tardy, slow, not pulling his weight and whatever. Unfortunately, the 3 panelists must make up for that latitude. It's an internal efficiency. Your appointment is collective and it's joint and several. So, it's either they set aside the award. They're not going to set aside the award of 1 arbitrator and keep the remaining 2. No. So you're all working together. What would happen is, at the end of the day, you are better informed. So if somebody now mentions that lazy arbitrator's name, you know how to make a run for it. That no way. I know what I experienced under these circumstances. But for the while of that circumstance exists, you have to manage yourselves. Vote with, you all have equal votes. You all have equal rights. So no one is superior to the other. But, it's just that a presiding arbitrator is given more prominence because he presides. And it is expected that he would render the award. But of course, you all work towards the award. So you may have the presiding even being the sole minority. Though it's rare because oftentimes, yes, we say the party nominated arbitrator or party appointed arbitrator is objective, is independent, is all that. But the truth is, you have two people looking at the same issue from different angles. So the idea of that presiding arbitrator is to break that vibe, to decide that, okay, do I prefer this person's line of argument or do I prefer the other party's line of argument? But as I said, sometimes you have a convergence of views. All the three will agree because it will be so clear, so obvious that, hey, the facts presented, this is the guy that should have this decision in his favor and not any other person, and but I'll tell you, once the maturity again of the arbitrators come to question, you find that you really won't have any problem with co-arbitrators coming to a decision at the end of the day. But do you have a hung decision? No. No. The worst that would happen is two will be for, and then one will give a dissenting view. But then, under the Act, the majority carries the day. So whoever has the two votes has the decision.
Absolutely. Thank you so much for that. I want us to move on soon to the Q&A because I'm sure there are questions for our distinguished panelists. But I have two more questions that I would please want you to indulge me. So the first one has to do with, have you had any arbitrator being challenged, that you have to rule? This is a 3-man panel and one of the arbitrators has been challenged for one reason or the other, whether for conflict or for something else. And your panel has to rule on it. How did that go? Mrs. Roberts, would you like to share with us if you've had that kind of experience before?
I have not experienced that before.
Okay.
Perhaps I think I've sat with people who are quite diligent about conducting their conflict due diligence before they accept appointments. But having said that, it is not that it cannot happen, but it is not the co-arbitrators that will rule, quote and unquote, on it. You can't force an arbitrator who is conflicted to resign. You can advise, you can tell him. I know of a particular matter that a friend of mine was presiding, and she had this issue. One of the co-arbitrators was actually challenged by one of the parties, and they showed him that he was conflicted, and he refused to resign. And he told the parties to go to court, and they were in court for quite a significant number of months. I don't know how that was resolved, but perhaps he was persuaded to resign. But you can have yourself in that kind of situation. But the point remains that it is not like you don't have the power to remove an arbitrator. If the parties feel strongly that that arbitrator is conflicted and the arbitrator refuses to resign as arbitrator, then the parties have the option of challenging him. But like I always say that conflict situations are not cast in stone. You may start off the arbitration without any knowledge of any conflict situation. And then along the line, because your obligation to disclose is a continuing obligation from the date you are appointed to the date the award is published. And I always say that if you are not certain of a particular situation, whether you are conflicted or not, disclose it. You don't have anything to lose beyond the parties saying that they don't want you to be appointed as the arbitrator, because it is always better to err on the side of caution than for you to be challenged by a party. And then I've heard of instances where in fact, this was a very well-known matter. The gentleman in question did not even realize that he was in a conflict situation until one of the parties brought it up. And it was like, how did this happen? I didn't know that. I mean, being a minority shareholder in a company will turn into a big issue for him. So, like I said, there is no hard and fast rule about anything. But one thing is certain: if you are conflicted and it has been shown, there's really no point. And like Sakiola said, if somebody who is recalcitrant and insists on continuing the arbitration and setting up the award for setting aside proceedings, I would not want to work with that kind of arbitrator again. And in the instance that I was telling you, I had the opportunity of participating in the appointment of a presiding, and this guy's name came up, and I said, no, I would rather not appoint him and let the court appoint him, or the default appointer make the appointment, but I'm not going to appoint him and then find myself in the same situation as this. So
interesting. Thank you, Ma. My last question is...
Can I just add to that though? Sometimes the reality is that whatever due diligence you undertake, somebody may still challenge if they think it is for strategic reasons. I've been challenged, notwithstanding that there was no conflict, there was no discernible impartiality. The challenging party's premise was that given the size of our farm, we must have acted for the other party. That was simply the premise. and you know, notwithstanding our demonstration that I carried out a conflict check, this is not on our client list. The simple argument was it cannot be so. The nature of this other organization is such that, you know, this law firm must have acted for them. And Mr. Ohaga is a partner in that law firm, and therefore there must be a conflict. I mean, of course, it was eventually dismissed, but that's the point. The point is that sometimes challenges are not bona fide, and they have no proper grounding.
Thank you very much. Thank you for that. I want us to, we have a lot of questions already, but I wanted to ask a question around the award itself. What makes for a, you know, like a foolproof award? How does a three-man arbitral tribunal come up with a foolproof award? How is the work shared? Does somebody write, you know, a part of it? How does it work in practice? And you know, what are the sort of challenges that, you know, you can encounter along that, you know, trying to now write the award? We've agreed, we've heard the parties and all of that, and we now want to write our award. And how have you overcome those challenges, you know, to still come up with a robust and foolproof, you know, award that even when he gets to being challenged, you know, that he can stand the test of time? I would like Mr. Sales to answer that question, and Sir Akinola as well, and whoever else on the panel wants to chip in is fine.
Well, thank you, and I'll try and keep it brief. It's such a big topic because, of course, our primary duty, when you want to look at it in simple terms, is to render an enforceable award. The process leading up to that is somewhat wasted if we can't deliver that. So the quality of the thoughtfulness, the inclusion, and by that I mean having covered all the issues raised in the award, is really, really important. And sometimes that sort of dictates that it's best drafted in the hands of one of the three, with the other two being used to sense check, to cross-reference, and to bring the richness of thinking into it. But often I find that the quality or the consistency of the drafting is best if a person takes the obligation. Quite often that's the chair, but quite often the chair is the busiest of the three tribunal members, so one of the party appointees might pick up that sort of the heavy task of doing the actual drafting. Other times, I must say, I have received draft awards from chairs that unfortunately needed to be rewritten, and so the other party appointee and I rewrote it. And so it really depends. I think the ownership of it is a very important thing. It's a very important thing to me. So if I had a preference, I would have to say if I'm signing something, I quite like being the person who has drafted it, because I have a very sort of set process for sort of producing an award. That means I know that I've sort of encompassed all of the arguments and all of the evidence and all of the material. But it does depend. It does depend on the makeup of the tribunal, the busyness of people. I find my experience of where, three of us have written parts of the award. Yes, it's good to divide up the work, but honestly, at times you spend as much time editing to bring all the language into a consistent unit that it kind of makes the separation of the tasks a little bit of a waste of time. So my preference, I have to say, is a single person drafts, whether that's me or the chair or whoever, and that the other two of us spend our energy contributing to the sense testing, the complete coverage of all the material, etc., all of that side of the award, which is really important as well. So that's my preference.
Thank you. I like that. Sakiola?
Yes, well, basically, I think what is expected is for an award to be clear, reasoned, and enforceable. And in doing that, dividing the work, um, um, the one that I'm more comfortable with, I can liken to what Paul says, is first of all, having due expectation on the presiding, because there's a reason why the presiding gets 40% and the co-arbitrators get 30%. So usually if you are the presiding, if I'm the presiding, what I would do is prepare the draft award, share it with the co-arbitrators. Then you have a session at that session, of course, the co-arbitrators are expected to do a critique of the draft award. In areas where they agree, the session that you're having, farming the award and releasing it, you affirm the various issues with contention and decisions taken on each of them. And at the end of the day, by the time you harmonize your views with what drafts you're working with, you have a beautiful draft. Even in situations where you carve out sections that, okay, arbitrator A, you take this part, arbitrator B, you take this part. You must have that convergent meeting. You must have that meeting where you put all the issues together and then you harmonize the award, because award is not going to be construed in arbitrator A said this, arbitrator said, then at the end of the day you have a scrambled egg, or what do you call it, a situation where this section doesn't fit into that, or the conclusion is different from what has been reasoned in the earlier part and all. So conclusively, somebody drafts. Most times, the presiding. If the presiding doesn't want to draft, he can switch off one of the co-arbitrators to do the draft. And I mean, note what I'm saying. I call it the draft. Then it is when the three arbitrators meet, then you firm up the draft and it becomes the award. In areas where you agree, you agree. In areas where there are dissent, you express your dissent. And if after that meeting, you find that the areas of agreement, are less than areas of dissent, then you are free to now do your own award and do a decent award and say, hey, I have gone through the draft award. I disagree in these areas and that area, but with harmony in the work of the arbitrators, I believe you would have an award rendered. The best that would happen is two people thinking or seeing it one way, one party seeing it differently. Thank you.
Thank you very much. Very clear. Mrs. Roberts and then Mr. Ohaga,
I think
quickly,
we
so that
should
we can
take
go to the
John
questions.
first. John,
Oh,
you
okay.
can
You
go
want?
first. Yes.
Okay.
Yes, I was going to say that I learned my lesson the hard way. In one tribunal, we agreed that we would split the writing of the award into different sections.
Terms.
Procedural section, and then the hearing and the evidence, and then the merits. And then it fell on me to try and harmonize. And what I found was that the writing styles was so different
It's always different.
that the harmonization was a real nightmare. And so I go back to, I agree with Paul and Chief. I think it is best that one person draft and then you can review. But the thing is, prior to embarking on the drafting, you will have met, you will have discussed the different issues arising, and you will have some consensus. Your pathway to a decision might be different, but you will have consensus, hopefully, on what your outcome should look like. And then you embark on the drafting. I don't think that you can draft and then circulate for agreement. I think that's putting that's really turning it on its head. It's best to agree, so there are no surprises. I might not agree with the way that you have expressed it, or the path that you have chosen to get to that answer, but at least I know what conclusion we've all agreed we need to get to.
Yeah. Yeah. Thank you. Thank you. Very well. Very well said. Claire, Mrs. Roberts.
It was as if either John has heard my story before and he has helped me to tell that story. Believe me, the arbitration I was talking about with the two retired justices, I did all the work from the first procedural order, and then to underscore what Chief Akiola and John and Paul had said, the tribunal must meet as soon as possible. If you are new to the game, don't let the experienced arbitrators make you skip that part, because it is going to unravel somewhere along the line. In that particular situation, the presiding, immediately after the 2-day hearing, I asked him, sir, when are we meeting? Oh, he said, I would let you know, I'll communicate a date with you. And I left it. Unfortunately, he told the parties that the award would be ready on a particular day without discussing with the members of the tribunal. And he gave like 2.5 months. And I was like, what is wrong with this man? But of course, you can't contradict the presiding in front of the parties. So I said, sir, but you've told them 2.5 months and we have not met. After some time, I gave up. And then 2 weeks to the deadline, I just saw an email with a draft award. And I was like, when did we agree anything regarding this arbitration? I then called him and said, my experience sitting on the bench, I was a high court judge, I went from court of, and he went on and on. I said, sir, I have read your award and I am not going to append my signature to this award.
Wow.
Fortunately, the other Supreme Court justice also had not read it. He was happy to go along with the presiding. And I said, look, I'm we are basically on the same road as far as the decisions are concerned, except for one or two that I would have loved us to talk about. But even the way the award was drafted, it was as if he completely forgot to read the rules regarding how, and he said, okay, Mrs. Roberts, but I would like all of us to sign this award. I said, I'm not going to sign the award, but I'll write my own award as a minority award. 2 days later, he called me and said, Mrs. Okay, can you redraft the award? I said, after we have met. So I forced that meeting. And by the time we finished the meeting, they realized the importance of having held that meeting. And then, but it is almost 9 days to the date I promised that the award would be ready. Fortunately, I'd started writing my own. So I volunteered to rewrite the award. And I didn't finish until the morning that you were supposed to publish the award. But that you have to be confident enough to stand your ground. Otherwise, particularly for young arbitrators, and there's a piece of advice I give to young arbitrators. Avoid taking a sole arbitration if you don't have that confidence. If you mess it up, if you don't do a good job, the news will spread, and then you begin to suffer reputational damages. Try and work on a 3-man panel, learn as much as you can, because being a sole arbitrator is a lonely road to travel. Left to me, I would prefer to do more of 3-man, but my lot in the last 2 years, I've mainly been sole arbitrator until I got appointed a week ago for a presiding. But there is a lot to learn if you're working as a team. And also a great deal depends on the person you appoint as your presiding. If you appoint the wrong person and you are better skilled in arbitration than your presiding, you may end up either doing a lot of coaching or doing a lot of the work, which has been my experience. But I'd rather do the work and come up with something that I can append my signature to than take a laid-back attitude and just put my signature on it. It has reputational consequences at the end of the day. Thank you.
Thank you very much to our distinguished panelists. It's been an awesome session. And we have questions. I've gone through the questions, and honestly, I feel that a lot of them have been answered in the course of the discussion. So maybe people came late or maybe didn't hear, but I'll just take one because really we are the time is fast spent, and we still have the chair closing and our the chair of the SEAB also closing the session. So, but I will just take one or two. One is, can we have a unified conclusion that arbitration is not an ADR in the same category like mediation, negotiation, and conciliation, considering the high cost? I think we spoke extensively about costs, honestly, but it still seems that it's a sore point. And I think we've learned how best, the principles that we can use to manage the cost. So maybe I will leave that out because it's something that has been exhaustively discussed. Are there prescribed timelines from when a preliminary hearing holds to when the award is given? Or this is based on the timelines the parties agree to? Mr. Ohaga, your hand is raised, so I think you want to say a bit, and then you can also answer this question.
Yeah, well, no, I was going to just give an interesting anecdote because Fumi keeps talking about sitting with retired judges. Mine was interesting because it was having retired judges appear before you. And so I wasn't sure whether I as sole arbitrator, should I say, yes, my lord, what do you have to say? And so on and so forth. There was a question there of how does the tribunal address counsel when counsel are retired judges? I just found that very interesting. But with respect to the question of timelines, It really depends on the legislation. I'm presently sole arbitrator in a matter that is out of Uganda, and Uganda has a defined timeline within which the award must be rendered. And so what has happened is that the parties have had to keep going back to court and ask for an extension in order to validate the award. Otherwise, the statute nullifies the award if the award is rendered outside the defined timeline. So it really does depend. It depends on what rules you're operating under, whether it's LCIA or PCA. There will be different timelines. There will be different mechanics for presenting the award. There are rules which require that the court, for instance, review your award before you publish, and so on and so forth. So it really is a question of what rules you're operating under. You have to be very familiar with the rules and the underlying legislation.
Thank you very much. Well answered. There was also one question around why the Arbitration and Mediation Act 2023 failed to provide a scale of charges for the fees of an arbitrator. So I'm just saying that this question around cost and fees is really a burning one. So I don't know whether there's any insights, Mrs. Roberts, on that. I know that I think you were involved with that in some way. So over to you.
It's actually the chairman of the committee that drafted that law. I answered that question in the chat by saying that if you can tell me an arbitration law that has prescribed fees, then I would know. But I know that India has something like that, but then it is not too prescriptive. And I say that, look, if it is an institution, you don't have any choice but to go by the institutional scale of fees. I would hesitate to pull a scale of fees in a law because the dynamics will change completely. Inflation may arise. The parties may not even be able to afford the prescribed fees. There's so many, from the conversation we've held today, you realize that the issue of fees can be dealt with in different ways, taking the circumstances into consideration. You don't want to put it in a law that it will take you 10 years to amend, because it took us, Chief Akela, I don't know whether you remember how many years it took us to get that law passed. I think 9 years. So if you have a scale of fees and the inflation has risen by about 50-something%, there's absolutely no way you are going to get that law or that scale of fees changed for another 9 years or even more. There is actually no need to put it in the law governing arbitration. You have a plethora of institutional scale of fees online that you can use as guidance to deal with that issue. So that was why we didn't put it as part of the law, the AMA.
Well noted. Thank you. There was a question around if when parties have to a loan facility have agreed in their contract that they will take the dispute to arbitration. There has been an arbitration agreement, but one party decides, to go to court to resolve it. That is it possible to do that? Is it possible to do that and get away with it? I'm not going to answer the question. I've been in situations something like that, but I'll leave it to Mr. Sales. Do you want to answer the question?
Certainly, and the very short answer is no. You can't get away with that. The whole premise of the parties having agreed contractually to go to arbitration is that they are bound by their contractual agreement. And so the model law and most, if not all, arbitration legislation throughout the world addresses that in a stay of proceedings. So if one of the parties tries to go to court when they are and trying to get around their arbitration agreement, then typically the arbitration legislation modeled on the UNCITRAL model law says no, there is a stay of proceedings and the matter is referred back to arbitration. Because as I've taught my students at university, typically, and we talked about this earlier, when the parties are in dispute, one of the parties, typically the respondent, always wants to forget that they signed an arbitration agreement and always wants to forget that they have agreed to appoint three people to determine their issue, etc., and then always wants to, or typically wants to, forget to work in good faith to bring about a resolution of that matter. And so if we didn't have the protection of this stay of proceedings within the national legislation, every second, if not nearly every arbitration agreement would be, worked around by a party who doesn't want to follow that process anymore. So no, that's enshrined in every law in every country around the world. So again, short answer, no, you can't do that.
Thank you very much. And on that note, I will just invite our panelists to say their last words. What's your advice to your last words to us as we make that transition from, counsel to an arbitrator? We've learned a lot today from you, all of you. You've shared practical experiences with us. But what do you want to leave us with that we'll keep thinking about? So, Mrs. Roberts, you started it, so we're starting with you.
Very much. What I would like to say is the fact that because you are counsel does not mean that you make a good arbitrator. And I always tell people that arbitration was not started by lawyers. It was started by people in the build industry. But when we lawyers come into the fray, we take over. So you don't have to be a lawyer before you become an arbitrator. But whatever the case is, even if you are a senior advocate of Nigeria and you want to go into arbitration, get yourself certified and credentialed by going for trainings, because the mindset and a whole lot of things may change in the course of your arbitral practice. Thank you.
Thank you very much. To Chief Akinola, what habits or practices have helped you become more effective as a tribunal member? So that's what I would like for you to leave us with.
Basically, I would say that one's integrity plays a major role. Once parties know that if you are part of the panel or you are appointed an arbitrator, you will get what it is they deserve. I guess they'll be comfortable with you. Bottom line for everybody is start small, um, try and be appointable. Being appointable simply means maintain your integrity and reputation. Once those are kept safeguardedly and jealously, be rest assured things will come your way. But please never be too much in a hurry. A lot of people have seen some questions on the chat group. How soon can I get my appointment once I become an arbitrator and whatever? Just make yourself visible. Fumi Roberts told you the circumstance by which she got her first appointment. She didn't rush to become an arbitrator. She was comfortable being an arbitral secretary. Providence gave her the first appointment. Then she started riding on that. Now she's a world certified arbitrator. Hard work, hard work, hard work. But the bottom line is, please let us ensure, seek for training. You're 40 years at the bar, you're 50 years at the bar, you're 30 years at the bar, does not guarantee you will make 1 minute of a good arbitration. Of being a good arbitrator. Go for training. Go for training. The justices of the Supreme Court, with all the experience they've had, at the end of the day, the rules of procedure of arbitration stands out. You must learn it. Thank you very much.
Thank you very much. Thank you very much. Very, very solid advice. And Mr. Ohaga, just taking from one tribunal dynamics that surprised you when you first sat as an arbitrator? Can you use that, to sort of give us your own closing guidance for people that are, making that transition or want to be like you, in the field?
Yeah, that's an interesting question. I remember one of my earliest cases, obviously in my eagerness to be ready for the hearing, I had read through all the material, and I was very familiar with the material. But mentally, I was approaching it as counsel. And so as the parties were going along, in my mind, I was thinking to myself, why don't you ask this question? And I almost wanted to prompt counsel to ask a specific question because I thought it was dispositive of a very central issue. And they were not getting there. And I found myself getting very impatient. And also mentally judging counsel. And what it taught me was that, you have to be patient. You cannot judge until you've had the full case, until you've had all the parties, until you've had the arguments, until you've listened to the law as intertwined with the facts, and so on and so forth. As arbitrator, you must exercise restraint. You must not prejudge. The counsel eventually came to the point. I just wanted him to get to it earlier. That was the problem. And so there is a very different mindset between being an arbitrator and being counsel. Being counsel requires, I think, slightly more aggression, slightly more very party-oriented thinking, whereas being an arbitrator requires you to give the fullest opportunity to all the parties to put forth their case. Sometimes whatever you think of their case, you must allow them the full runway and then deliberate. And I often think about, just going back to the writing of awards, I often think about it as defensive writing, because, as Paul said, you have a responsibility to render an enforceable award. And so when I'm writing an award, I'm constantly aware of the potential minefields, the potential areas for challenge. And so I try and navigate my way around them to ensure that you sort of bulletproof your award. So those are some of the things that I have learned.
Thank you. Thank you so much. Very rich. Mr. Sales, if you could go back to your first ever appointment as well, what insider advice would you give us and would you give yourself, something you learned from your first experience that you would like for us to go home with today?
Look, a couple of things. I very much echo what all my very learned colleagues have said in their closing remarks. And John's point, I think, particularly, one of my mentors when I was starting out as an arbitrator said to me, write every one of your awards like the person who likes you the least in the world is going to read it and pull it to pieces. I remember that literally every time I am writing. I think when you go back to your sort of first appointment, a lot of it comes down to confidence. You are having your first procedural conference with parties. How do you conduct yourself? How do you, all of these first time things are very difficult. So the more that you can take your time, as we've been talking about in these closing comments, to train, to understand the process, to try and sit in, if you can, if you know colleagues who would allow you to, even though it's private and confidential, anything that you can do to sort of understand how you need to address that early procedural stuff in your first hearing and your first award, because they are all very new to you, and we've all got to start somewhere. And just taking the time to prep yourself so that you are as confident in that unfamiliar space as possible. And so that, you know, that process is not a surprise to you. The contents of a procedural award are not a, you know, of a procedural order are not a surprise to you. And we're lucky, there's so much rich content on the internet now that can help guide you in those first steps. But really, you know, underlying it all, if you've prepared yourself well, have confidence in what you're doing, portray yourself confidently, and understand, I think, final point, understand how influential the way you address those first year engagements with the parties are in terms of everybody's expectations for the process, how they're going to conduct themselves, what they are or are not going to try and get away with as parties, how you frame those initial meetings and things does set the scene for the entire rest of your process. And that you probably don't understand that until you've got a few under your belt.
Great.
Enough from me.
I'm sure we can never get enough of this panel. If we have to do this again tomorrow, this webinar will still be packed full. Thank you so much.
You need to give me the opportunity to make this point, please.
Okay, ma.
I want to ride on what something John said, to the effect that you have to write the award with the limited reasons why the award can be set aside behind your back. I want to build on that by saying that your commitment to, for example, Section 55 of the AMA, which sets out the grounds upon which an award can be set, begins from the very first day you are appointed. So the grounds for setting aside, you must bear it in mind from the very first day of your appointment. Anytime you need to make a decision, you have to look at it and see, is this decision going to be affected by Section 55 in any way? So don't wait until it is time to write the award before you bear in mind the limited grounds upon which the award can be set aside. You must have it in mind. You must know those grounds, breathe, eat, and sleep with those grounds, because it will then aid you and guide you in taking the right and follow due process in the course of the arbitral proceedings. Thank you.
Thank you so much, ma. What a wealth of experience, skill, knowledge we've gone through today. Please, let's give our panelists, our distinguished panelists, a round of applause. They deserve much more than that. Thank you so very much to the four of you. It's been amazing this afternoon. And I've been writing, even though I'm moderating, I've been writing, and I know a lot of people have gone with books full of things that we've learned today. I would just like to hand over to, Dr. Eson, our chair, who is best placed, to give the thanks to our distinguished panelists and the closing remarks. Thank you. Dr. Eson, over to you.
Okay.
Yes.
Okay, so it's been a wonderful afternoon, very engaging and very insightful. And all the speakers, you've done excellently well. I am overwhelmed with gratitude. Thank you so much. And the comments, the feedback, even from all of the comments, has been very phenomenal. And to this, I am very grateful. We will continue to learn from you online, offline, anywhere we can. And lessons, so many lessons have been learned. Start small, low-hanging opportunities. Mrs. Roberts said she started by being a registrar, and a lot of people may not want to take up that opportunity, but you'll learn a lot from that, and it could be something that will land you your first appointment. And in terms of managing arbitrators, tribunal dynamics, we've learned so much today, and also learning not to be coerced into accepting any appointments, any nomination. So many things have been learned, and everybody that's joined, they've had one or two things to go away with, and for this we are grateful. And our moderator too, you've done an excellent job moderating this session. We are grateful for all of your time. And to our participants, thank you for joining us. We'll have this webinar every month. Another one will come up early next month. And for CHAP Nigeria, we have a lineup of programs we have shared on the chat box. Our training calendar, feel free to look through it or go to the website CHAP Nigeria to see the lineup of all of our programs. Our flagship event is our annual conference. Is coming up 4th to 6th of November in Port Harcourt. You will learn firsthand, and you will see all of this, our lovely speakers. You will learn firsthand more about arbitration, the practice, the procedure. It's promising to be very interesting and exciting. The registration details will be shared in the next couple of weeks. We'll also let you know. What else? I think that's about it. Thank you, everybody, for joining us. And Mrs. Robert, we are grateful. Mr. John Ohaga, we are grateful. Mr. Paul Sills and Chief Akingbola Akinola, we are very grateful. Leonard Silk, thank you so much. And on that note, I'm going to call on the branch chair, Mrs. Olushola Adegbomire, to also say one or two words and to also thank everybody. Mrs. Adegbomire, please.
Well, what can I say but a very, very big thank you to all my ogas and to Mr. Sills. Thank you very much. Chief Akinola, our past chair, Mrs. Roberts, Mr. Ohaga, thank you very much, Mr. Sills. Even I have learned, I think we have all learned a lot in this webinar. This has been a very big one. And I don't know how Dr. Eson managed to round up all these people. I don't know how you did it, Dr. Eson. But when you told me to take 2 hours, I said 2 hours. But when I looked at all the names again, I could understand why. These are the big ones, and I want to thank every single one of them for making the time. I'd put remember everywhere that this one I cannot afford to miss. And I'm happy I joined at 2 and I'm still here at 4. And like Mrs. Bidemi said, if we could continue, we would continue. Thank you so very much. I've learned a lot. I know we have all learned a lot. I know that this one will impact our arbitration practice. If everybody had the opportunity to say one thing they've learned, everybody will have one thing to say. It has impacted mine, and I know it has impacted for so many people. Thank you very much. And like Dr. Eson said, I know that when we call on you again, you are all people who love to give. I know every single one except Dr. Sills that I don't know very well, but I'm sure he's here because he loves to give. But you are all people, like Mrs. Roberts said, I want to go away empty. You are all people like that. I know you very well. Thank you very much. Thank you, Dr. Eson, that you keep coming up with all these amazing, brilliant webinars. And the whole CCIC team, thank you very much. Our moderator today, you did a great job. You pulled out everything from inside of them. And we say thank you. And to everybody behind the scenes, and there's so many people behind the scenes in each of these webinars, thank you very much. And for all those who have attended, you are all very welcome. At this time, we still have so many people. We still have 310 people on this webinar. Thank you very, very much. If we had 310 in a room, that would be a lot of people. So thank you very much. Dr. Eson, back to you again. And from wherever all our speakers are calling in from, well, have a good evening, good morning, good afternoon, and thank you again.
Thank you very much. Have a great
Thank you
rest of
very
the day.
much. Thank you very much. I don't know who, Bidemi, do you know how to take the snapshot of all the speakers and everybody? Or who knows how to use that function? And if you're still on the call, if you want, you can put on your camera to take a snapshot of everybody. Mrs. Adegbomire, please, you want to put on your camera? Is there anybody that knows how to do that? I don't know how to. Okay. Anyway,
I'm doing the manual one. Don't worry. I took something, but Mr. Adegbomire, your camera wasn't on. So, okay. I think maybe, I don't know. Maybe she's not able to, but I've taken it. Thank you very much.
All
Okay,
right, thank
Ireti.
you. Ireti, yes, put on your... I forgot to thank Ireti, our section coordinator.
Well
Thank you
done,
very much.
Ireti.
She did
Thank you.
fantastic.
Well done. Yes,
Fantastic
indeed.
Fantastic
job.
job.
Indeed.
All right.
Indeed.
Thank
Well
you.
done.
Thank you. Thank you,
Bye.
Ma.
Thank you, Ma.
Bye-bye.
Thank you,
Okay,
sir.
so
everybody.
for me, John
Bye-bye.
and
Eh,
Paul, have a lovely one.
Yes.
it's a
And
Thank
pleasure
you,
to
Chief.
meet Paul. John, good to
Okay.
see you again.
thank you very
Sakiola, I
much.
didn't know you were chief before. You didn't invite me to the
I'm
knighthood.
I'm
Eh?
a knight of St. John's now, so
Absolutely. And you didn't invite me to that wonderful ceremony.
we
Hearty
thank God.
congratulations.
Thank you,
Well
thank
done.
you.
Well done.
Thanks. Okay.
Bye,
Okay,
everybody.
then. Thank
Thank you,
you.
everybody.
Okay.
Bye.
Bye.
John, were you in
Bye.
Paris?
No, I'll be in Madrid.
Oh, okay.
My
You're coming
chief,
to Madrid. Okay.
Chief
Yes, yes.
Akiola, Miss
Sholahan now,
Robert,
my chair,
Eh,
my
yeah,
chair.
our chair.
everybody, chief, bring back
Wonderful
something.
chair
Chief, bring something for me, oh.
No
Mrs.
from
Robert,
Madrid.
Mr. Haga, how is Cameroon?
He's gone.
Oh, he's gone.
Okay, then.
Chief,
Take care,
chief,
everyone.
bring something for me, oh.
No problem, my chair. Have a lovely
Mrs.
one.
Robert, she
Thank
gone.
you. Thank
Thank you
you.
so
Bye.
much.
Okay, bye.
Bye.